Hi, everyone. Welcome to the Disability live stream, Disability Law. My name is Sivan Tumarkin. I'm a lawyer, I'm a disability lawyer, and I'm here to answer questions about disability. So if you have any questions as we go through this, please feel free to type them in, send those to us. And even after the live stream, I'll be more than happy to speak with you. We don't charge anything for speaking with people, for consulting with people, for making sure that you're empowered and that you understand what your rights are. So let me get right into it. This week was a particularly interesting week with regards to a bunch of questions that I received from people from different parts of the country. We help people across the country with their long-term disability claims. And this one had to do with return to work. Now, this is really important. Some people who are already on long-term disability because of an illness, because of an injury, or a combination of both, oftentimes ask themselves at some point, can I go back to work? And of course, the insurance adjuster is interested in you trying to go back to work. And oftentimes they will try and goad you. Some people have reached out to me and said, I'm being pressured, I'm being forced to go back to work. So what you need to understand is that the insurance company cannot force you to go back to work when you are on long-term disability. It may feel like they're forcing you, but they really don't have the ability to force you. Here's what they can do, and oftentimes they try to do. They try to coerce you, they try to persuade you in a tough way to go back by telling you that if you don't try to go back to work by a certain date, your benefits will end. So people reach out to me and say, look, I'm still disabled, I'm still struggling, I'm still going through treatments, I've spoken to my doctor or doctors, and they've told me that I'm not ready, I can't go back, not just to my job, but to really any job. And my answer is, look, for you to be comfortable to go back to work, to try to go back to work, you need to be comfortable with it, and your doctor needs to be comfortable with it. So you speak with your doctor, and if you feel that you're not ready, and your doctor feels that you're not ready, you need to let the insurance company know. And if, despite that, the insurance company maintains that they're going to cut off your benefits, your long-term disability benefits, you have recourse. The insurance company cannot unilaterally decide that you're ready to go back to work if this is not correct. If you are not feeling that you can go back to work, or your doctor says that you're not ready. So what do you do in that situation? Well, I'll tell you this. Here's what you should not do. And this has happened now multiple times with people who have contacted me after the fact. Number one, you think that maybe you can convince the adjuster, you can give them more information, you can appeal that decision that they have made that your benefits will end because you need to go back to work when you're not ready. So they try to engage the adjuster head on, and it's okay to start that way. It's okay to let the adjuster know, look, I'm not able to. Here's a letter from my doctor explaining why I am still not ready to go back to any occupation, not just to mine, but to any occupation. And if the insurance company at that point maintains their denial, well, you have legal recourse. This is where we jump in. This is when we can help you with that situation, because the insurance company is simply not allowed to do that. What the insurance company is effectively trying to do, and I'm not being cynical here, I'm just telling you both anecdotally and also because I've been in the industry now for more than 2 decades, is the insurance company is playing a numbers game. They understand that there is a certain amount of people who are going to give up, who are going to accept what the insurance company is saying, and either they're not ready to go back to work and they'll say, okay, well, I guess my benefits will end. There's nothing I can do about that, which is not true. Or they will try to go back to work even though they're not ready. And they will try to go back to work again, sometimes medical advice. The doctor says, you are not ready. The problem there, obviously, which is a natural issue, is that if you in fact try to go back to work, that may aggravate your condition. It may create a worse off situation. So it's really important to understand that, it's one thing to try and get the adjuster to understand that you're not ready and provide information from the doctor saying you're not ready. It's another thing to feel like you have no choice here. And if the benefits end and the insurance company can just force you to do this and etc. They cannot. You have a lot more power than you think. And again, this is what I explain to people. When insurance companies unilaterally make moves, you need to call them up on that. Don't accept what the insurance company is saying at face value if it doesn't make sense to you. Now, what happens if you think you are potentially ready to try a return to work program? Ideally, that's what should happen, right? We want people to try and get better so that they can, in fact, at some point go back to work. Well, what happens in that situations? In a situation where you're back to work, you've been there for a day or 2 days or a week, and things are not going well. You are clearly not ready. You thought you might be, your doctor thought you might be, but you're clearly not ready. What do you do about that? Well, Under most long-term disability policies, you have what's called a recurrence clause. It is a clause, a provision in your insurance policy that stipulates that within a certain period of time, when you try to go back to work, if you're unable to go back to work, if you're unable to sustain that work, you should be able to go back on LTD without waiting the initial, what's called the elimination period, the initial period of time where you don't get paid, where the insurance company wants to see that you remain disabled from the time you apply and the time that you qualify for the LTD. So you try to go back to work, you see that it's not working out, you go to your doctor, you explain to your doctor, it's not working out, I'm not feeling well, whatever the symptoms are. The doctor writes a note or a letter, you submit that to the insurance company, you say, look, I need to be off on LTD. This is premature for me. I need more treatments, I need more time off. The insurance company at that point should put you back on claim without any issues. Theoretically, that's what should happen, and sometimes does happen. Unfortunately, sometimes that doesn't happen. The insurance company, again, blocks that. They may say, well, we're not sure that you tried hard enough. We're not sure that you're still disabled. We're looking at the initial letter that your doctor wrote to us saying that you are potentially ready to go back to work. They may cherry pick information from there, and they may again say, we're not paying you. Again, you have an option here. The option is to pursue them legally, which is, again, what we do. So it's really important to understand, I'm not telling you you have to do this. I'm telling you you have legal options. The insurance company cannot simply unilaterally stop paying you when they have a legal obligation under the insurance contract to pay you LTD benefits. So it's really important to understand that you do have those kinds of rights. I also have a lot of people obviously contacting me because they have issues with their employer. I'm not an employment lawyer. We have other employment live streams, and we have, of course, employment lawyers at the firm, and they can help you with the employment issues. But oftentimes there is an interplay between employment law and LTD law or disability law, and people have questions about both. Well, we have lawyers that have dual specialties that actually focus on both areas of law. So if you feel like you're stuck between a rock and a hard place, between the LTD insurer or the short-term disability insurer, whichever insurance you have, and your employer, you can, in fact, speak to somebody on my team that has a dual expertise, and they'll help you with both. And the two areas, in fact, overlap in the event that, for example, you let go from your job. If you're disabled and you're on LTD, you may get severance. You may want to know how that severance may be affected or may affect the LTD payments, because there is an effect there. Again, if you have any questions, please post them. Please put them out there. I try to go through them and answer them as quickly as possible to get to as many of you as I can. I want to talk about something else here. Oftentimes, people who are applying for short-term disability don't expect to be off work for longer than 3 to 6 months, which is typically the period of time that you have short-term disability for. And then, of course, they find out that, no, this is a long-term issue or a longer-term issue, and they're going to have to apply for long-term disability. What do you do in that situation? Can you expect a smooth ride between STD transitioning into LTD, into long-term? Are there issues in between? Do you have to do anything? Again, people are very anxious about that, understandably so. Here's what you need to understand. Whether the short-term disability coverage is with the same insurance company as the long-term disability coverage, or sometimes you don't even have STD coverage. Sometimes you have to apply to government for employment, for medical insurance, for unemployment insurance due to disability, sick EI, for example. It doesn't matter. The point is this: whether it's the same entity or a different one that's going to be paying you LTD, you may get a different adjuster. It should be smooth sailing because the test to get short-term disability ought to be similar or the same as for long-term disability. Unfortunately, again, it depends on who is on the other side, who is receiving and assessing your application. You're not always going to get the exact same person or the same people or the same team. So I have had situations where somebody qualifies for short-term disability. Let's say it's a mental health issue. Let's say it's a physical issue or an illness, an injury perhaps. And then when it comes to long-term disability, well, guess what? The person was denied, and they have no idea why. And when you look at the medical documentation, really, there wasn't a change. The person is still disabled. They still can't perform the essential tasks of their occupation. So the question then is whether or not you can do anything about that. Well, you can. Number one, while you are on short-term disability, it's really important to understand that you need to continuously you need to continuously speak with your medical doctor, and you need to continuously undergo treatments. And when the time comes for you to apply for long-term disability, you want to make sure that you get updated medical documentation, medical reports, a letter, something from your doctor saying you remain to be that you remain disabled. So it's really important to understand that you are, in fact, not that there's an obligation on you, but you need to understand that you need to be proactive about these kinds of things. So that's very, very important. Now, what happens if you are denied LTD, but you were, in fact, accepted for STD? Well, it's very important to understand that in that situation, most likely, we can get that reversed fairly quickly. We can contact the LTD insurer, and oftentimes there is force there from us, this coming from us, from our side, with our letterhead. Unfortunately, oftentimes when people apply for LTD, again, insurance companies will play the odds that if they deny your claim, maybe you'll walk away, because there are people who in fact do that. So you do need to understand that you need to be persistent, and this is where we come in. Exactly. This is where we answer your questions. We can represent you. We can help you with these issues, but don't give up. Do not if you are disabled and the insurance company has denied your claim, please do not give up. I want to go to some of the questions here that I'm seeing. Question from Haley on YouTube. I have done a functional limitation assessment and transferable skills test. What is the next step? If I got a denial, what should I do? Okay. What Haley here is talking about is when the insurance company is trying to figure out how to cut off your benefits or how to end your benefits. They will send you to certain assessments. They can be medical assessments. They can be an assessment to test your skill set, your functional limitations, to figure out if they can somehow come up with perhaps a list of occupation or jobs that you can do, so that they can point to those and say you're no longer disabled from doing those other occupations. The thing is this, Haley, this is what you need to understand, that the fact that the insurance company sent you to this assessment, first of all, you need to understand that this assessment was paid for by the insurance company. Secondly, the insurance company is the one who who gave instructions to the assessor. The insurance company is expecting a report that is going to help them potentially end your benefits. Doesn't always happen. Okay, it doesn't always happen. Sometimes it actually backfires on the insurance company. But this is what the insurance company is trying to do. So what do you do if you get denied, or the insurance company comes back after the assessment and says you're no longer entitled to LTD benefits? In that case, again, you reach out to me, because I want to see exactly what happened. I want to understand. I want to read the assessment if you have a copy of it. If not, we'll get that from the insurance company. I want to understand what your disability is. I want to understand what your doctors have said. And the reality is that, look, I don't care what the assessment says. If you say you're disabled and your doctors say you're disabled, I am telling you right now, we can go after the insurance company and we can force them to pay you what you're owed. And the process is actually not complicated. It's just that it's a technical process. There's a legality to it. There's certain steps that have to be taken. As a lawyer, right, I can walk you through that. If you want to go to sleep, I can bore you with the details. But the point is, the insurance companies do this all the time. It's not a unique situation to you, unfortunately. This is something that happens time and time again, and it happens with skill assessments, with functional limitation assessments, with independent medical examinations where they send you to one of their doctors. This happens all the time. You have options if the insurance company comes back and says, based on this assessment, we think you can do some other job, and therefore we're going to end your benefits because we want you to start going back to work. Again, if you feel you cannot go back to work, if your doctors confirm that you're not ready to go back to work, they will not be able to force you to go back to work. Seeing some other questions here. Can an insurer ask your doctor about commensurate occupation at the 10th month mark when you're in the 2-year own occupation period? Okay. Let me kind of break this down for our listeners here, for the viewers. First of all, I think an insurer should be able to communicate with your doctor if you give them permission to, and they will seek permission. They will ask you for permission. And there's nothing inherently wrong in having the insurance adjuster speak with the doctor. But can the insurer ask the doctor about commensurate occupation? What that essentially means is, can you do another job, another occupation? That's essentially what commensurate typically means. We typically see this at that 2-year mark when you're an LTD. Why? In this case, this individual who's asking the question is asking about the 10th month mark, and I'll tell you why that's a bit odd in a second. But typically under most long-term disability policies, to get long-term disability benefits, you need to be disabled from performing your own occupation for the first 2 years. To get benefits beyond the 2-year mark, again, under most policies, the test is no longer your own occupation. Can you do your own occupation? It's can you perform any occupation for which you are suited for by training, education, or experience. What we typically look to try and gauge whether or not there is a job or occupation you can do that is different than yours, but for which you are trained for or you have experience or education in, is commensurate income. What does that mean? Typically, based on the typical way that these things go, if you can get a job at that 2-year mark where you can earn about 60, 65, 70% of your pre-disability income, then the insurance company will take the position that you are in fact capable of working in another occupation. Again, let's say you made $100,000. I'm using just a simple number here, $100,000 before your disability. If at the 2-year mark you can find a job that pays you $65,000 a year, $70,000, the insurance company, and you can maintain that position, you can work in that position, not just for a week or a day or a month, but longer. The insurance company will take the position that in fact you are able to work in a different occupation. The reason why it's odd that the insurance company, in this case, this gentleman who's asking the question, the reason why it's odd that this insurance company is asking the doctor about commensurate occupation is because, number one, they're doing this at the 10th month mark. So it's not even at the 2-year mark. It's 10 months after. That's very strange. Usually doesn't happen. Tells me that the insurance company has some kind of other knowledge or suspicion that perhaps you are not that you are able to work. Again, it's just strange to me that they're asking at the 10-month mark if you can do commensurate occupation, meaning you can do some other job, because you're still within that 2-year period. If anything, they should be asking the doctor, can you do your own job, your own occupation? So something here is very strange to me. But frankly, your doctor, I don't think, should be answering that kind of a question. Your doctor is not an assessor that deals with these kinds of issues. Your doctor can provide medical information to the extent you provide consent for your doctor to give that medical information. What are your functional limitations? What is your diagnosis? Things like that. Things that are medically based, not can you do some other job. So I don't think that it's an appropriate question. And if it was up to me, I would tell your doctor, don't answer a question like that. Certainly answer the questions of what are my limitations, anything to do with my medical condition that prohibits me from working, but not can you find or can you work in a different occupation where you can earn commensurate income. That's 60 to 70% of your pre-disability income. Moving on, I got denied from my anxiety claim. My doctor has been helping me through it, but I'm worried about getting everything together before the appeal deadline. Can I ask them for more time? Okay, several things here. Number one, as soon as I see the word appeal, I don't like it. These appeals, I've said this many times before, you can go ahead and appeal these denials. You can go ahead and appeal anything the insurance company does and says. But the reality is that in the vast majority of cases, you're appealing to these same people who denied you in the first place. So unless you are going to provide them with something that is so exceptionally different than what you provide them already, why would they change their mind? And even if you did give them something different, again, it's the same people who denied you in the first place, same company. It's not an objective third party. It's not a judge. So people ask me, okay, you say don't appeal. What should you do? Well, speak with us. Let me see exactly what you applied, what you gave the insurance company. Let me see the denial letter. It doesn't cost anything. Again, I can tell you in 3 minutes whether or not you have legal options, whether or not you should do this or you should do that. Take from it whatever you want. I'm not going to force you to do anything. It's your claim. You want to appeal again, no problem. I'll give you tips on how perhaps you can make your appeal better. But the reality is these appeals often go nowhere. They take time and they create more anxiety. Now, it's interesting that you have an anxiety-related claim. That's a mental health type claim. Unfortunately, many insurance companies still they haven't gotten the memo that psychological claims, psychological disabilities are sometimes even more debilitating than physical injuries or illnesses. And oftentimes, frankly, they're intertwined. When you have chronic pain, when you have illnesses of various sorts, you're not just dealing with the illness or the physical pain, you're dealing with the psychological after effects. psychological issues that come from that: depression, anxiety, sometimes PTSD, phobias of various kinds, etc. So to answer your question briefly, you're asking, can you ask them for a extension of time for the appeal? You can ask whatever you want. They'll tell you yes or no. But realistically, there's one date you need to keep in mind, which is the 2-year limitation period for starting a legal claim against your insurer for a denial. And that 2 years starts running from the date of the first denial, not the date of the appeal, not the date of the denial of the appeal, the date of first denial. But I can tell you, again, up to you if you want to play their game of appealing and reappealing. I think most of these appeals are frankly useless. I've seen people fail doing them time and time again. When we get involved, we send a letter to the insurance company, we start a legal claim, we resolve these kinds of cases. You know why? Because while you're appealing it, it doesn't cost them anything extra. It's the same adjusters looking at the stuff, maybe a different department, but it's the same insurance company. Literally cost them nothing to deny you again. Why is it different when we start a legal claim? Because now they have to get a lawyer involved, whether it's an in-house lawyer that's on salary or whether it's a lawyer like myself that works for a defense firm, the kind of firm I used to work at 20 years ago. They have to now write checks for legal services. They have to now pay lawyers. I can tell you, and I've said this 1,000 times before, and I'm telling you this as somebody who's been on the other side. One thing and one thing only insurance companies hate more than paying out claims. It's paying out their lawyers to fight these kinds of claims. Because for them, it's lost money. So that's why legal claims are so powerful. It's because you're essentially making them bleed money by having to activate their lawyers who are charging them by the hour. And yes, even if they're in-house lawyers, those lawyers are on salary. There's only so many claims they can handle at any given point. So once you have taken up the time of that lawyer, they have to hire another lawyer. So either way, as soon as the lawyer is dealing with this, they are now going to be bleeding money. It's in their interest to try and resolve your case, and that's leverage for you. Question on Facebook from Danielle. My mental health condition is covered under my policy, but they say there's a 24-month limitation. Are mental health disabilities treated differently than physical disabilities? Fantastic question, and it has different layers here. 24-month limitation, 2 years, right? We spoke about this earlier. Typically, when you have a claim, an entity claim, most people get hit with that 24-month number, the 2-year mark. I can tell you right now, under the vast majority of disability policies, these policies typically go to age 65. Some of them go more, older, the golden type of policies. Some of them are restricted policies. They're for a short period of time, 2 years, 5 years, 10 years. It's not common though. So when an insurance company says your claim is only for 24 months, for 2 years, you must understand that what they may mean and likely mean is that the first 2 years for you getting LTD, the test is your own occupation. Can you do your own occupation? Can you work in your own occupation? People conflate that, sometimes because the insurance company is being unclear, but they conflate that with thinking that, oh, I only have benefits for 2 years. No. And Danielle, if you wanna just verify that, number one, get a copy of your policy, because it's going to stipulate early on how long the policy is for and when it terminates. And if it says it terminates at 65 years old, well, it's 65 years old. It's not 2 years. Number one. Number two, you can ask the adjuster. Ask the adjuster, here's my policy. Can you please tell me, when does the policy terminate? Again, don't take their word for it necessarily. Tell them to point you to the provision that tells you where it terminates. But I can tell you that most policies do not terminate at 2 years. Now, you're saying it's a mental health issue, and you're saying it's covered under the policy. These policies cover not mental health issues or physical issues. They cover, can you perform your job? Can you perform the essential tasks of your occupation? That can be a mental health issue, that can be a physical issue, an illness, a combination of any of these. There are policies out there that are injury-only policies. So what they'll tell you is that we only cover you if your disability arose from an accident, from an injury of some sort. But even there, it's not always clear, because sometimes you had a pre-existing underlying condition that was triggered by an accident. Let's say you have a bad back, you fell off the bed falling off was the accident, but you had a pre-existing condition. The insurance company may deny your claim on the basis that it's an accident-only policy, but guess what? You have a pre-existing issue for your back. Well, there's an argument there that even though the accident was the trigger, still, it's not the accident that's really the cause. It's the pre-existing condition that underlies the cause. I'm getting a bit technical, but my point to you, Danielle, is no, most policies are not 24 months. They take you to age 65 if you cannot work in any occupation for which you are suited for. Okay, sir, can you explain or outline the pre-approval and approval process step by step for short-term disability? Okay, so it's not a pre-approval. What you need to do here is you need to, let's say you have extended health benefits through work. Let's say your disability coverage is through work. You have to make sure that you go to your HR or the owner of the company, whoever it is, and you ask them for the policy that applies to you, the disability policy, and it will outline the steps. It will tell you, you need to fill out this form. Your doctor may need to fill out a form. Your doctor may need to provide some kind of a letter, explanation of the nature of your disability. That's it. That's pretty much it. Like, you need to basically give the information that the insurance company needs in order to evaluate your claim for disability. And the reality is that if you know you're disabled, if your doctor says you're disabled, then here's why. Okay, this is important. The doctor has to explain why your condition is disabling, why your symptoms prevent you from working. If you have that, you should be approved. And if you're not approved, I want to see the denial letter. And I will tell you if what the insurance company is saying is correct or not. Because I can tell you, they have a bunch of excuses for why they deny claims. We see those time and time again. I always remember this one individual that I helped a few years back. I think the denial letter in his case had about 12 different reasons the insurance company gave for why he did not qualify for LTD. I can't tell you the name of this individual, but I can tell you that we had started a legal claim. Within less than a year, his claim was settled for close to $300,000. Again, specific case, every case is different on its facts, but understand that the insurance company will try and deny your claim if they can. Don't take that denial face value. You reach out to me immediately if that happens. Okay. Haley also mentions here, this was a follow-up. I have also a WSIB claim, which is workers' compensation. I have an oral hearing of appeal to attend. I have been on LTD for 2 years, and I'm being assessed for change of definition. Should I pursue both or just give up on WSIB? That's a good question, because most LTD policies will contain a provision that allow them to get a credit for anything you get from WSIB. It's going to be too difficult for me to give you a precise answer without understanding more about your situation. So my suggestion, Haley, is reach out to me after the live stream. Either myself or a member of my team will speak with you, we'll get information, and we'll tell you what to do. Because depending on the facts, depending on what's happening, the type of disability, what happened exactly, we may advise you differently. So I don't want to mislead you here or not give you enough information. Again, it won't cost you anything to speak to me or a member of my team. Okay, so please make sure that you reach out. Okay, we're coming up to the end here. Let me just see if I can get more questions. What is the best kind of medical documents to provide if you're told that what you gave is not enough? Okay, good question. I want to throw this website out there that we've created a long time ago. It's called ltdfaq.ca, ltdfaq.ca. It contains short memos answering those kinds of questions that you're asking me right now in plain language, plain English. It's free. You can get that. It'll tell you exactly. But let me just answer this. Here's the medical documents you need to provide to the insurance company. Something from your doctor or doctors. Usually I say don't give them a paper napkin that simply says, the doctor says you're disabled. It needs to be a bit more substantive. You don't need a letter that is 5 pages long. You need something that has potentially 2, 3, 4 paragraphs, something that outlines it's your family doctor or it's your specialist. Here's the nature of your disability, or here's the nature of your limitations. Here are the symptoms that are disabling you. And in the opinion of the doctor, you cannot work at this point. It needs to be as detailed as possible. The more detailed, the better. If the insurance company doesn't accept that for any reason, reach out to me, because oftentimes insurance companies say, insufficient medical documentation, this is not enough. Trust me, it's nonsense. If the doctor outlined exactly what the issue is, the insurance company ought to accept that. The problem is, and insurance companies, again, play that game. They want to make you think like you haven't provided enough documentation, enough medical support. So it's really important to understand that you need to be able to respond to that. And it's not by going to a different doctor, and it's not by necessarily going to your doctor and getting more information. It's by understanding what your legal rights are at that particular moment. So I can explain that to you again. We're out of time, unfortunately. I know that there's other questions. I want to also mention a couple other websites just because we're out of time. mydisabilityquestions.com. mydisabilityquestions.com. It's on the screen right now. We've had this website for many years, many. There are thousands of questions. We answer these questions 24 hours a day. Okay, one of our lawyers doesn't sleep. Literally, we answer those. Go and post your question. You'll get answers. You can always reach out to us directly, phone, email, whichever way you want. It doesn't cost anything to get the information. One more website before we go: pocketdisabilitylawyer.ca. pocketdisabilitylawyer.ca. It's a bunch of drop-down menus. You can customize it and get the information you need. You have a question, a concern, go to it. It'll take you 10, 15 seconds to select the correct things that apply to you. And this will give you the answers you need, or at least a starting point. Again, if you want to speak with us after that, no obligation, doesn't cost anything, please reach out to us. Thank you for joining me. We're going to have other live streams. We have an employment one. The disability one. The next one is coming up next week on Tuesday, March 10th at 10 a.m. Pacific time. Martin Willems, our partner in BC and Vancouver. You're going to love his South African accent, and the guy is one of the top lawyers in that province. If you have questions about your employment, join us for the employment law Q&A. Thursday, March 5th, so that's tomorrow at 2 p.m. Eastern Time with Jeremy Herman, one of our star employment lawyers out of Toronto. Thank you for joining. And again, reach out to me, to a member of my team, by email, by phone, any of these websites to get the information you need. It won't cost you a dime, I promise you. Thank you.